All right, check this out. You had a charge maybe years ago. It got dismissed. You thought, okay, that's done.
Right. Put it behind you.
But then, bam, it pops up. Background check for a job, maybe trying to get an apartment, even just volunteering, still there.
Mm-hmm. Like a shadow you can't shake. It's frustrating. And it holds people back.
Seriously. But what if you could actually make it disappear? Like, poof, gone for good, erased like it never even happened.
That's what we're getting into today. That power exists.
Welcome, y'all. We're here to break down the complicated stuff, make it plain, and give you the truth you can use. Today, we are walking through something critical. Criminal record expunctions right here in Texas.
Yeah, this is important. It's not just about laws and courts. This is about your life.
It's about getting that clean slate for real, taking back control.
Exactly. And we're grounding this conversation in the new Texas Criminal Record Expunction Guide. It's fresh for 2025. We're specifically looking at Chapter 55A of the Texas Code of Criminal Procedure. This law kicked in January 1st, 2025, and it changed the whole game. Made things hopefully clearer.
So our mission today is simple, right?
Straight up. We're going to break down what expunction really means, help you see if you or someone you know might qualify, talk about what's new with this law, and most importantly, show you how knowing this stuff unlocks that clean slate. It's about empowerment, giving you that truth and clarity for the journey.
All right, let's start with the basics then. What exactly is expunction? Like, break it down.
Okay, simplest terms. It's complete erasure. Think of it like taking a permanent marker to your history, but in reverse. You're wiping away the record of an arrest to charge, poof.
Not just hiding it, but erasing it.
Erasing it. Police files, court documents, everything related to that specific incident, gone.
And listen, this ain't just some legal talk. This hits home. This affects whether you get that job you need, right?
Absolutely.
Or find a decent place for your family to live, even just helping out at your kid's school. This stuff matters. It's about getting your future back on track, writing your own story again.
That's the heart of it. And looking at the bigger picture, expunction, it's about justice. It's about believing in second chances, real second chances. It gives people a legitimate path to move forward. To contribute, to not be defined forever by one mistake, especially if it wasn't even a conviction.
Right, especially then.
It's about restoration, allowing folks to live out their God-given potential without that weight holding them down.
Okay, now here's where it gets really interesting. Especially if you thought you knew the old rules, like before this year, 2025.
Big changes. Huge.
The whole foundation for expunctions got flipped. That old law, Chapter 55, it's gone. Repealed. Put out to pasture.
Completely retired. Now, everything, for adults anyway, falls under this new Chapter 55A.
Chapter 55A.
Got it. And it's designed to be more structured. It clearly lays out two main roads, mandatory expunctions and discretionary ones.
Okay, mandatory and discretionary.
Think of it like a system upgrade for the law itself, trying to make it more predictable, fairer, cut down on the confusion.
All right, let's dig into that first road. Mandatory expunctions. That word mandatory sounds powerful.
It is powerful. Mandatory means if you fit the description in the law, the court has to grant the expunction. It's not an if, it's a when.
No wiggle room for the judge.
Not on these. It's your legal right.
Yeah.
This is where your claim is strongest, your clearest path to freedom on paper.
Okay, so what falls under mandatory?
Well, Chapter 55A breaks it down. First, you got Subchapter A. The guide calls these automatic rights. These are situations where the law says, yep, clear this record quick.
Like what?
Okay, number one, trial acquittal. You got arrested, felony or misdemeanor, went to trial, and the judge or jury said, not guilty, acquitted.
Found innocent.
Found innocent. All those records got to be erased. And fast, usually within 30 days after the court gets notified, the system acknowledging the truth.
Okay, that makes sense. What else?
Second, pardons. If you received a pardon, maybe for actual innocence, maybe for other reasons, that conviction gets erased. Same deal, usually within 30 days. A pardon's a big deal, a statement of forgiveness or correction.
And the law respects that. Good.
Third, there's a specific one for certain old unlawful handgun carry convictions. If it happened before September 1, 2021, under a specific part of the penal code, that record can be expunged. Again, 30 days.
Wow, specific.
And fourth, mistaken identity. If your record only exists because someone else's mess got wrongly pinned on you.
Oh man, that happens.
It does. And if that's the case, your identifying info linked to that wrong arrest can be wiped clean. 30 days again, correcting the error fast.
That's good. Clear rules.
It really is. Texas law is surprisingly clear on giving you these rights in these specific situations. Not much room for argument there.
Okay, so that's subchapter A, the automatic ones, but you said there's more under mandatory.
Yep, that's subchapter B. The guide calls these other mandatories after release. This applies when you are arrested, but listen close, no conviction happened, and no community supervision unless it was just a Class C fine-only thing.
So arrested, released, no conviction, no probation, basically.
You got it. If you meet those conditions, there are more ways expunction becomes mandatory. These cover those cases that kind of fizzled out in the system.
Like how? What are the scenarios?
Okay, probably the most common one. No charges were ever actually filed against you within the legal waiting period after your arrest.
There's a deadline for prosecutors.
Exactly. The clock starts ticking. It's 180 days for Class C misdemeanors.
Yeah.
So small stuff, usually just a fine.
6 months. Okay.
It's 1 year for Class A or B misdemeanors. Things like maybe some theft or minor assault charges.
All right.
And it's 3 years for felonies. Or even if a felony popped up from the same situation. So if the DA doesn't move forward within that time...
Your record can be cleared. Mandatory.
Mandatory. Another way. The DA, the head prosecutor, formally certifies, basically puts it in writing that your arrest records aren't needed anymore.
They just sign off.
Pretty much. Or if the official charge document, the indictment or information gets dismissed or quashed,
Or no.
thrown out.
Why would that happen?
Could be lots of reasons. Maybe you finished a veteran treatment program or a mental health program or something called pretrial intervention. Good programs.
Okay.
Or maybe the charge itself was flawed from the jump void, a mistake, not enough evidence, what they call probable cause.
Gotcha.
And one more. If the time limit to even file charges, the statute of limitations ran out before they even filed anything, you're entitled to expunction then too.
So if the system doesn't follow through or resolves it without a conviction, you get that clean slate.
That's the goal. Justice demands it, right? Giving you that chance to move on fully.
Okay, so we've covered the musts, the mandatory expunctions, crystal clear. But what about the gray areas, cases where it's not a guaranteed yes?
Right. That brings us to the other path, discretionary expunctions. That's under subchapter C. And the key word is discretionary.
Meaning the court can, but doesn't have to.
Exactly. The court may grant it. They have the option. They look at the situation and decide if it's the right thing to do. It's their judgment call.
So you got to make a case for it.
You do. You're asking them to use their discretion. So what fits here? One main situation is if you had a final conviction, but it got overturned by a higher court, an appellate acquittal.
Like the Court of Criminal Appeals?
Yeah, or a court of appeals. They reviewed your case and said, nope, this conviction was wrong. Once all that appeal stuff is totally finished, that opens the door to ask for a discretionary expunction.
Okay, overturn on appeal. What else?
The other big one is if the district attorney recommends expunction before a trial starts, but only for a fine-only offense, like a Class C misdemeanor.
So the prosecutor agrees it should be wiped?
Right, but only for those minor fine-only cases and before it goes to trial. Now, the timing here isn't that quick, 30 days like the automatic ones. It depends on how long appeals take or when the DA makes that recommendation.
So still good options, but less certain than mandatory.
Less certain, yeah. Requires the court to agree it's appropriate.
Now this is just as important, maybe even more so. Knowing when you can't get an expunction. The roadblocks.
Crucial. Subchapter D lays out the expunction prohibitions. These are the absolute no's. Even if other things seem to fit, if one of these applies, expunction is off the table.
The system draws a line.
It does. Understanding why helps see the intent. Why keep certain records? Usually public safety or accountability.
Okay, so what are the main prohibitions?
First, the same criminal episode rule. If the charge you want expunged happened during the same incident as another charge that did lead to a conviction or is still being prosecuted.
You can't just erase part of it.
Generally, no. They keep the whole picture together. Also, if you were arrested just for violating your probation or community supervision rules, that arrest usually isn't expungible.
Makes sense. Accountability.
Right. Another big one, if you absconded, meaning you skipped out, ran, disappeared after being released following your arrest.
You gotta face the music.
Pretty much. Running usually blocks you from using those waiting period rules we talked about. And here's a specific one. Not guilty by reason of insanity. If that finding happened after September 2005, it's not treated as an acquittal for expunction.
Why the date?
The law changed then, likely reflecting ongoing concerns about monitoring and public safety in those specific cases. It's viewed differently.
Okay. Any others?
Yeah, there's some really specific rules about records tied to driver's license suspensions or revocations. Only very narrow exceptions allow expunction there, under specific parts of the transportation code.
So it's a balance. Second chances, yes, but not wiping everything if there's an ongoing reason to keep the record.
That's the tightrope the law tries to walk. Restoration, but also responsibility.
Okay. Now, everything we've talked about is for adults, right? What about kids? If the trouble happened when someone was under 18?
Totally different system. Very important distinction. Juvenile records have their own set of rules. Don't mix them up.
Where do you find those rules?
That's under the Texas Family Code, Chapter 58. It's not just a mini version of the adult system. It's designed differently, often with more focus on rehabilitation and sealing records.
So kids might have an easier path sometimes.
Often, yes. For example, lots of juvenile misdemeanor adjudications things under the Alcohol Beverage Code, maybe even truancy, can often be expunged once the young person turns 18.
Yeah.
The idea is not to let childhood mistakes shadow an entire life. But again, you got to check the family code for the specifics. Different playbook.
Good to know. Okay, so let's say someone listening thinks, okay, I think I fit, I think my situation qualifies. What do they actually do? What's the practical path forward?
All right, let's walk through the how-to. It starts with getting your ducks in a row. Preparation is key.
Step 1.
Gather your documents, all of them. Get copies of the arrest warrant, court papers, the dismissal order, the acquittal verdict, a pardon certificate if you have one, everything related to that case.
Proof. You need proof.
You absolutely need proof. Having it all organized makes everything smoother. Step 2. Prepare the petition. It's a formal legal request, usually called an ex parte petition.
Where do you file it?
Depends on the original charge. If it was a felony, you file in district court. If it was a Class C misdemeanor, you file in the Justice Court or Municipal Court where it happened. Got to get the right court.
Okay, file the petition, then what?
Step 3. Notify the right people. You have to let the district attorney's office know. And any police or sheriff's departments that have records on you from that arrest, they need official notice.
So they know you're asking for erasure.
Exactly. They're part of the process. Step 4 is the goal. The judge reviews everything and hopefully signs the expunction order.
The magic paper.
That's the one. Once that order is signed, the law enforcement agencies must destroy or return your records. They can't keep them accessible. And they have to tell the state, DPS, the Crime Records Service, to clear their databases too.
Okay, total wipe.
Yeah.
But what if the court says no, even if you think you qualify?
Good question. If you believe your expunction was wrongly denied, you can challenge it. There's a process called a restricted appeal. But you got to act fast. You usually only have 6 months to file that appeal.
So don't sleep on it if you get denied.
Definitely not. Deadlines are real. The whole process takes effort. But it's designed to work if you meet the criteria.
Man, that's a clear breakdown. Let's try and wrap the key points up. Chapter 55A, the new law since January 1st, 2025, is the roadmap now in Texas.
That's the guide, and it sets up those two main paths, mandatory and discretionary.
Mandatory means the court must grant it. Think acquittals, pardons, certain dismissals, waiting periods expiring.
Right, and those timelines vary. Could be 30 days, 180 days, 1 year, 3 years, depending on the situation. Discretionary means the court may grant it, like after an appellate court win, or if the DA recommends it for a fine-only case.
Less of a sure thing, but still a path. Still a path?
Yeah.
And just as vital, remember when it's not possible. The prohibitions, convictions without a pardon, related charges in the same incident, probation violations, absconding, post-2005 insanity findings.
Knowing those no-go zones is critical.
Absolutely. It's all about understanding where you stand legally. Knowing the truth empowers you.
For real. This whole conversation just shows how powerful knowing these details can be. It's not just legal stuff. It's about getting that true fresh start, that clean slate we talked about, the freedom to really move forward without that past mistake or wrongful arrest dragging you down. It's about getting your future back.
And connecting it back, this is bigger than just paperwork. It's about reclaiming your narrative, your God-given destiny. Understanding these pathways to restoration, that gives you agency. You feel me?
Yeah.
So think about the impact. An expunged record changes a life. It helps heal communities. It shows we believe in second chances when the law says it's right. It lets people truly thrive. Beautifully said. We really hope walking through this gives you clarity, gives you confidence. Whether it's for you, your son, your neighbor, knowing this truth can change everything.
Keep seeking truth. Keep pushing forward.
And if you need help navigating this, remember where to go.
That's right. Visit legal-gangsta.com. Let me spell that out for you. legal-gangsta.gang.com.
And for our listeners in Harris County specifically, go to legal-gangsta.com right now. Get your 10-step Erase Your Criminal Record guide. It'll help you start that journey to freedom, to that clean record today.
Don't wait. Take that step. legal-gangsta.com.